A big concern in technology products is intellectual property. And this is a topic I know something about, considering I've had trademarks as well as, oh yeah, I did have a copyright, and 30 patents. Last time we talked about cost, and now it's what is the value in what we're producing? So research objectives are what's my market, who's my competition, what's the value of my product, and how do I protect my product? So why do we have IP? It determines the valuation of your company, helps you raise money. It's intangible, meaning it hasn't actually been produced anything yet, but it shows the potential of your company. It also could be tangible because it's property. And also, this is the basis of when you can harvest. If you haven't produced anything, you could still sell your patents. Property is anything that's owned by a person or entity. There's real property like real estate. Then there's personal property, which is considered to be everything else. The USPTO says intellectual property are creations of the mind. They have to be embodied in some kind of form. They have to be able to, so you can share them, emulate or manufacture them. And there are 4 kinds of intellectual property. There are patents, trademarks, copyrights, or trade secrets. And that's what we're going to go over today. Patents are inventions. Trademarks are brand or product expressions. Copyrights are considered to be creative works. And finally, trade secrets are things that aren't known to the general public, like the Coke formula. In terms of legal documents, there are patents, registered trademarks, and registered copyrights. Obviously, there's no publication of a trade secret or it wouldn't be a secret anymore. Anyway, what they want to do is by benchmarking that you've achieved this, they're hoping to spur innovation, that people will surpass you and also protect your creation. They generate assets for your company. They help you defend what your company has produced. And it also gives you leverage when you go negotiate, because you have something to negotiate with. Creative rights are, can you prove something that you created was created uniquely by you? You own the rights to it. For example, you own the rights to what you look like. Patents are something you own the rights to. Publications are something that you own the rights to. Trademark is a mark coupled with a product or service. It could be a word, color, a smell, package design. TM means it's unregistered. You might have seen that written. But what you're doing is you're giving notice to people that I'm going to assert my rights on this. And when it's federally registered, then you see an R. So you have legal protection and you can sue people on infringement. Trademarks are used to identify and distinguish goods. The right is initiated once you have commerce. Until you actually are trading on it, then there is no trademark. And it's also what's called a goodwill marketing asset that informs the consumer about the source and the perceived value of the goods. And trademarks can't be functional. Functions are protected by patents. Slogans, short phrases, public domain are not protected by trademarks. And also, knockoffs are not considered to be protected by trademark. So 511, Butter It's Not, Eurocell, none of those are considered to be protected trademarks. Register and get your rights for your product in an established market. You have to inform the USPTO, but after continuous non-use for 3 years, you lose your rights. But once you're registered, it's good for 10 years, and it's renewable as long as your trademark is active, but you have to pay maintenance fees. Trademarks have to be distinct. They have to be relevant to what you do. And trademarks can become genericized. The word Xerox doesn't mean anything to you, but back in the 1980s, when people made copies, they always said, I'm going to go Xerox something. In the same way, it's okay to say, I'm going to Google it, instead of saying I'm going to go do a web search. It's okay if they become genericized. And that may not be a bad thing, because they're now part of people's language. Copyrights are creative works, and you have the exclusive rights and control of how, where, and when your works can be used, sold for a set period. They have to be in a tangible medium. They have to be original expression. And you cannot copyright a fact. It has to be separable from the action. For example, this is a picture that Dr. Cho drew, and he calls it a rock group getting stoned. Now, is this copyrightable? Is it in a fixed medium? Is it original? Can you attribute it to me? Yeah, it is copyrightable. You don't have to register copyrights like on your picture or something like that in order to own it, but it has to be in a fixed tangible medium. Notating a C on it, established notice, but it's not mandible. The length of copyrights, the life of the artist plus 70 years, or for a company, 120 years from the date of creation. And so, for example, Happy Birthday was under copyright for a very long time. What does copyright cover? Derivative works, meaning you improved on a work of something else so it became unique in its own right. How to distribute, perform, copy, and display what you're doing. You may be covered, but registering copyrights creates ownership. You can sue someone, but your copyright has to be registered. And how do you apply? Through copyright.gov. Now, if I want to sue somebody, what can I sue for? You can sue for the actual damages, meaning how much money did you lose and what did the infringer earn? Or statutory damages, which means you're punishing the infringer for stealing your work, which could be anywhere from $200 to under $50K. And copyright registration, what came first, 3 months within publication or 1 month of learning of the infringement? So if you learn about an infringement, you have to be aware of it so you can file it quickly. Other legal actions you could take is a cease and desist letter, send the infringer a license to operate without a bill, and the Digital Millennium Copyright Act. You can have, if something is like on the internet or something like that, you can ask them to take it down. Now, an example of legal action is Werner versus Autodesk. And what happens is that Timothy S. Werner bought software from Autodesk, and some of you might be familiar with Autodesk. ASU and Autodesk have a very close relationship. And what happened is he said, I bought the software, I have a right to resell it. And he was reselling on eBay, and they told him to stop. And so Werner sued Autodesk because they said they were infringing his right to sell his license to another user. And what happened is Werner won under what's called the first sales doctrine. Why is it that you're allowed to copy a CD song onto a recording and give it to somebody else? And it's called the first sale doctrine. Autodesk appealed, and it was overturned on appeal because the software that you're buying is you're licensing it. You do not own it. It's just like an apartment. You can't sell your apartment. You don't actually own it, but you're leasing it. And so the moral is, when you get that piece of paper with your software and all that fine print, yeah, read it, because there's probably copyright rights in it. In terms of software copyrights, first recognized in 1974. In 1980, they realized that people can make copies for computers. And the DMCA, which came out in 1998, which is in the heart of the dot-com boom, is, first of all, it creates safe harbors, meaning if you're just leasing web space or something like that, You're not responsible if somebody's doing something illegal unless you know that they are doing something illegal. And so software copyrights can also be about look and feel. Copyright concepts include fair use, what the courts deem as fair, copyleft that allows redistribution, look and feel, or things like typefaces or menus or buttons or boxes. Another example of a lawsuit is Viacom versus YouTube, which is now owned by Google. Viacom sued YouTube because they said on YouTube people were showing videos of their movies, and so they held YouTube responsible for it and sued them. YouTube claims safe harbor, that there's just too many people posting too many things. They were not aware they were doing this, and so they can't be held responsible for the behavior of their users. And so they went to court and they won, which I mean YouTube. And so Viacom appealed, and then it went to the Circuit Court of Appeals, and they said, yeah, there should be a trial. So they sent it back. YouTube won at trial, and the moral is lawyers made a lot of money. Now what's happening right now is the responsibility level of people like YouTube is being held higher, meaning the moment somebody's aware of it, then they need to go after them. They can't just let it slide. Most of the largest economies in the world have copyright protections. The thing is, international patents and international IP, it differs. They have different rules in the United States. Copyrights cover all these things: drawings, paintings, print, artistic works like songs or theatrical or choreography. Now, patents. Patents are only worth something if you're willing to defend it. The government is not going to go after anybody if they violate your patent. They consider this to be a commercial issue. But what a patent does, it gives you the right to exclude others from making what you made. However, in exchange for this protection, you have to publicly disclose your invention. And it also protects against innocent copying through reverse engineering. Invention means new, useful, and obvious. Non-obvious, the useful arts. Useful, the invention has to serve a purpose. It has to be new, meaning you can't find it in the prior art. It has to be a patentable subject matter, and it has to be non-obvious. And this is what's really fuzzy today about patents. And it says that it can't be obvious for a person of ordinary skill in the art. Well, what defines that? What's non-obvious to someone? And so patents don't mean utility. The hi-fi machine, for example. Somebody decided to file a patent, bird diapers. Now, it serves a purpose. Yes, I don't know, some bird crapped on somebody's car and they got pissed off, so they came up with it. But anyway, there's a lot of Looney Tune patents. The thing about patents is a patent doesn't protect the right to practice an invention. For example, you can patent a rowboat, but you can't patent rowing. Patent terms are typically about 20 years, but they can be voided because you have to pay maintenance fees, and the maintenance fees go up every year. This is one of the most shameful things ever, the America Invents Acts, and it happened under President Obama. And patent law was about first to invent. And then somebody came up with this fake story that people were filing patents and just sitting there with the patent and suing large corporations. First of all, those large corporations have so many lawyers. The odds of that person winning it are very small. Not only that, but patents are judged on, have they been reduced to practice? You just can't file an idea. And now they change it from first to invent to first to file. And now, even though you might came up with the idea first, if somebody else gets wind of it and files first ahead of you, you lose. And this is bad for entrepreneurs, because before you could wait, because patents are expensive, you could wait, and now you can't wait anymore. And the other problem is when you file too early, you lose the lifetime coverage of the patent. So there's something called a provisional patent. And what a provisional patent does is that you can file it as a placeholder. And then you have 1 year you just bought yourself a year. So you have a year to file the provisional patent and another year to file the full disclosure. Full applications are expensive. And then you got to wait 1 to 2 years. Typically, you need multiple patents for a product. A lot of products literally have hundreds of patents around them. So the key concepts is prior art, novelty, person of ordinary skill in the art, and obviousness. The kinds of patents are utility patents, and these are things of inventions and manufacturing, composition. Design patents. Lori Greiner of Shark Tank talks about her 200 patents. And I'm there like, how on earth did she get all those patents? Well, what they were are design patents. If you do something ornamental, you can patent it. You get 14 years of coverage. In a lot of cases, she bought things from other people and then patented it herself. And then you have plant patents that last 20 years. Why do they have a special category for plants? Well, when the patent office got started in the 1700s, what was the United States? It was an agrarian society. Now, in terms of patents, you can ask for re-examination. Very few patents get past the first time. Reissue is that you found an error in the original patent and you just want to fix it. Or maybe you want to improve it, but there's not enough there to be a patent by itself. And so that's another kind of patent. What's patent? You can read all these things. Now, the thing is, business methods are patentable, but it has to be tied to technology. For example, you can't patent Six Sigma. The power of the patent comes from your willingness to defend it. It's a long and expensive cycle through rejection. Patents are good for property, but weak on protection. Corporations file a lot of patents, and a lot of those patents are junk patents. And not only that, but I'm a little cynical of corporate patents, because if you look at them, you got 10 names on there. All 10 of those guys didn't work on that. They put down their friends and executives and people like that to make them feel important. But their head's on a stick. They're there to scare you away. Now, what is a trade secret? A trade secret is something of competitive advantage that's not generally known, and you've taken reasonable measures to preserve its secrecy. Meaning, if you tell your friends drunken in a bar or something like that, no, that's not reasonable measures. But the idea of trade secrets is, say I broke into a safe and I stole the Coca-Cola recipe. Well, technically, under the law, all I've stolen are pieces of paper. And so that's what I would be charged with, a misdemeanor, and they probably just kicked me out. So they came up with this idea of trade secrets. So now I am not stealing paper. I am stealing the Coke recipe. The protection of this is about misappropriation. The big thing is rights do not expire. An example of a trade secret that I had is I found out there was a difference in the processing between rinsing something 1 minute and 3 minutes. At 3 minutes, an oxide layer would come across silicon. Silicon oxidizes very easily, and that oxide layer would reduce your yield down. And so I never told anybody. It's a trade secret. Trade-offs that you worry about in IP are like timing, like biomedical companies that want to patent as late as possible so they get more years of protection. On the other hand, somebody might jump you. Should I file or not file? In general, if you can reverse engineer it, you should file a patent. If nobody's ever going to figure out what it is, you're better off keeping it as a trade secret. And does it align to your business? Now, an example of what goes on in the patent trade is Alphabet actually, and this is why Waymo is now part of Uber, because Alphabet owns a big chunk of Uber because they lost this lawsuit. They didn't get the $2.6 billion, but they got $400 million and they took it all in stock. And it's because Anthony Lewandowski, when you leave a company, they say, don't take anything that belongs to the company. Oh, everybody takes something. The big thing is, don't be dumb enough for people to know that you did take something. And so he took 14,000 files and they started integrating the technology into Uber. And of course, Uber said we knew nothing about this. And so, yeah, they did know. And so that's why they lost their lawsuit. Copyright protects creative expression, but not functions. Patent covers function, technical merit. So is software a copyright or a patent? And in general, they're patents. Employees, be careful that your creators can be your biggest leaks. The moment you start a company, get everybody under NDA, under secrecy. And even if you write it on the back of a cocktail napkin, have somebody sign it, because loss of IP happens a lot. So today we talked about the types of IP, that it's good for capital. It's good for something. Your company now has value, but it's not so great at protection because you need a lot of patents. The new patent rules, first to file, has hurt the entrepreneur. We talked about the government markings in order to get your protection, and trade secrets. And the reason why trade secrets are such a good thing is because there's no limit to it.